Hello everyone and welcome to Uncivil Law. For today's case, we have a decision from the Court of Appeals for the Third Circuit in United States of America versus Wayne James. In this case, Mr. James was a member of the Virgin Islands legislature, and he acquired money from the legislature for improper purposes. He's being charged with embezzlement and other related crimes, and he is going over the justice of his conviction. So we're going to read the case and what he did in terms of it. So let's get started with this. During the 2009 to 2010 term, James served as a senator in the Virgin Islands legislature. The legislature maintained a fund that James and other senators could use to pay for legislature-related expenses, such as the cost of running their offices, supplies, or for legislative initiatives. Senators sometimes received checks from the fund for such items. James used a large portion of the checks issued to him for personal expenses. James obtained these checks by presenting invoices purportedly associated with work on a historical project. Before becoming a senator, James took interest in the 1878 Fireburn, a revolt on St. Croix. The Danish National Archives possessed historical documents about the event. In February 2008, James inquired about retrieving documents from the archives and received a cost estimate. For a fee, which had to be paid by wire transfer, the archives would gather and provide copies of the documents to individuals outside of Denmark. James hoped to use the records to eventually produce a movie. Over a year later, after James' election to the legislature, he requested funds for his Fireburn research project from the legislature. From April 2009 through mid-October 2010, James obtained several checks by submitting false invoices for purported translation and research work for the Fireburn project. Only a fraction of the funds James received were used to pay for Danish records and translations. James used most of the funds for his personal benefit, including his re-election campaign. Law enforcement investigated this conduct, and on October 1st, 2015, a grand jury returned an indictment charging James with 2 counts of wire fraud in violation of law and 1 count of federal program embezzlement in violation of law. So far the factual background is pretty simple, all things considered. This person was a senator in the legislature of the Virgin Islands, the U.S. Virgin Islands, of course, which makes it a U.S. issue. And this person was interested in investigating a particular revolt that occurred in history, perhaps a noble goal. However, the way he chose to fund this was by asking money for one purpose and spending it for another purpose. So that makes it embezzlement. The legislature had set aside certain money for certain expenses, but he used it for things outside those purposes. He didn't use it for official purposes, such as running his office or hiring staff or things of that nature. Rather, he used it to fund this research project and also used it for his re-election campaign. So that converts official money into private money and makes it an embezzlement issue. So let's read on. And Jan's right. 18 U.S.C. 666. Yeah. Rock the devil. James challenges the introduction of evidence outside the statute of limitations, the government's attempt to introduce evidence of the payment in the eviction lawsuit, the use of the chart during the case's agent's testimony, and the substitution of an excused juror with an alternate juror after a jury polling. We'll address each of these claims in turn. So there's a variety of legal arguments here about why the verdict was improper. The first one is the question of what evidence can be introduced to help convict. And there's some evidence being introduced that happened before the statute of limitations. So the statute of limitations, as we're going to see in a minute, is typically 5 years for federal crimes. Some evidence is coming in from before that period. Is that proper? Let's read on. James argues the district court erred in permitting the government to introduce evidence of acts falling outside the statute of limitations. The general statute of limitations is 5 years after the offense is committed. To prove wire fraud, the government must show the defendant willfully participated in a scheme or artifice to defraud, with the intent to defraud, and use a wire to further the scheme. Wire fraud is not a continuing offense, but each wire may further a single ongoing scheme to defraud. Thus, mailings and wirings, that fall outside the statute of limitations can be considered as evidence to prove a fraud that occurred within the statute of limitations. So certain offenses are considered continuing offenses and certain offenses are not considered continuing offenses. For example, a conspiracy can be considered a continuing offense because the conspiracy continues, and also can be used to help backdate a statute of limitations if you can show evidence of the conspiracy that continues past the statute of limitations. Conspiracies to obstruct justice or elements of the conspiracy, a payoff in terms of the conspiracy. So, as a way of arbitrary example, and this obviously your mileage may vary, so don't take this to the bank. But an example would be like, suppose something occurred 20 years in the past. And suppose, one of my co-conspirators was getting a little bit flaky, and so I gave him money today. So that could be viewed as a continuation of the original conspiracy. So even though the conspiracy occurred 20 years ago, and thus would be considered outside the statute of limitations, the payment today, as part of that continuing conspiracy, could be read to continue the conspiracy all the way to the current day. So now we can go back 20 years and say it's within the statute of limitations because we have an event as part of that conspiracy that's occurring today. Now, obviously, whether or not it's part of the continuing conspiracy is a whole other can of worms. That's just an example, but it's an example of what they're talking about. So here they're saying wire fraud is not such an example because every example of the wire fraud is discrete. The wire fraud occurs on a particular event on a particular day. Now, conspiracy to commit wire fraud would be an example potentially of a continuing violation, but that's conspiracy to commit wire fraud, not the wire fraud itself. So here they're saying each wire fraud is distinct, and therefore each wire fraud can be viewed as within or without the statute of limitations. But as part of a scheme to defraud, you can look to evidence that occurred in the past because it's part of the common scheme and therefore is proper evidence. So that's a little bit about what they're talking about when it comes to continuing violations, non-continuing violations, and how those kinds of acts that occur later or before can affect statute of limitation periods. So that's just a quick overview of that. So hopefully that's helpful. Let's carry on. Because the jury may consider evidence outside the limitations period that proves the existence of an artifice to defraud, the district court properly permitted evidence predating October 2010. Such evidence includes James' submissions of false invoices. The fact that James's scheme began before October 2010 does not make evidence about his scheme from that period inadmissible, as is relevant to prove an element of a non-time barred crime, the existence of a scheme to defraud. James also argues the district court erred in refusing to grant a mistrial motion based on alleged prosecutorial misconduct. According to James, the government attempted to introduce evidence of an eviction matter that the court had precluded. So here the trial court said certain evidence can be talked about and certain things can't be talked about. That gets into evidentiary questions and district court discretion. And so the trial court said, well, there's certain things that cannot be talked about. Not atypical. What can be, can't be. These are motions in limine, typically, where they say certain things can't be talked about and certain things can be talked about. What is relevant and what is irrelevant. And here the district court decides certain things were irrelevant, but the prosecutor attempted to talk about them anyway. So does that make it improper for the district court not to grant a mistrial as a remedy? Let's read on. A prosecutor's comments continue reversible error only if they result in a denial of due process. The government may run afoul of the defendant's due process right to a fair trial by systematically injecting inadmissible evidence at trial, thereby permeating the proceedings with prejudice. We do not lightly overturn a conviction based on prosecutorial misconduct. The conduct must be viewed in context, and only by doing so can it be determined whether the prosecutor's conduct affected the fairness of the trial. And I do appreciate all the people who are liking, and although I don't really like overtly asking for financial support, it has been brought to my attention by fellow creators that my odds go up substantially every time I overtly ask for something, which is incidentally why I put in that ending you started to see in my videos that are being released with the please subscribe thing to make it overt, because it makes a difference. I don't really like doing it personally because it feels like, I don't know, it just feels a little bit weird. But that being said, if anyone wants to contribute with a super chat, I will read your super chat and I will appreciate it because it helps make the channel grow. So, I do have to, have some expenses, so it's helpful. But I also appreciate anyone. If you have literally anything that you need to spend money on other than this, then please do that first. And I just appreciate everyone who's here as well. Having someone to play off of makes this a lot more entertaining for me. So I really appreciate the comments and appreciate the chat, because it gives me something to play off of, and it goes to my impromptu and improv comedy that I've been working on. So having something to play off of makes it a lot better. So that's always appreciated. The government's efforts to introduce evidence from an eviction lawsuit against James did not deprive him of due process. The government nevertheless called 2 witnesses to testify to facts related to that case to show James' motive to steal taxpayer money. James, however, suffered no prejudice because the court prevented the witnesses from giving any testimony about the eviction case. The first witness the government called to testify about the subject, Gerald Groner, was not permitted to testify about any subject. He took the stand, and following a discussion between the court and counsel, was excused. When a second witness, Indria Chummy, was summoned to discuss the eviction-related payment, the court repeated, "We are not going there." As a result, the government's efforts regarding the eviction lawsuit did not result in the introduction of inadmissible evidence. James suffered no prejudice, and thus there was no misconduct that requires us to disturb the verdict. Accordingly, the court did not abuse its discretion in refusing to grant a mistrial. So that disposes of the issue of the evidence that was being introduced, whether it was proper or not, and the court says, yes, it is proper. But here there's set yet another issue, whether it was proper to dismiss the juror, and whether or not the court did the right thing in response to that request. So let's review what happened next. James argued that the district court abused its discretion when it declined to declare a mistrial after the jury poll revealed that a juror lacked the capacity to deliberate, and when it substituted a juror with an alternate. Decisions related to juror substitutions are within the discretion of the trial court. District courts have wide latitude in making the kind of credibility determinations underlying the removal of a juror. The federal rules of criminal procedure currently provide courts 3 options after excusing a juror for good cause during deliberations: declare a mistrial, proceed with 11 jurors, or seat an alternate. So here the jury had already sat, the jury had already begun deliberations, and the court is concerned that one of the jurors that is deliberating cannot do so fairly. It then dismisses that juror and is left with a potential remedy actions, and chooses to seat an alternate juror. Was that an error either to dismiss this juror, or was it an error to substitute a new juror? Let's read on. These 3 options come from 3 rules: Rule 31, Rule 23, and Rule 24. Rule 31D gives the defendant the right, and the district court the option, to poll the jury after it returns a verdict. The purpose of jury polling is to provide each juror an opportunity, before the verdict is recorded, to declare in open court his assent to the verdict with which the foreman has returned, and thus enable the court and the parties to ascertain with certainty a unanimous verdict has in fact been reached, and no juror has been coerced or induced to agree with a verdict to which he has not fully assented. So here we're in actually a pretty unique posture. I've never actually seen this happen before this current case. But here we're in the situation that not only was the jury did the jury get sworn in, not only did the jury hear the evidence, not only were deliberations occurring, but the jury actually had come back with a verdict. The jury had come back with a decision. And polling in this instance is when they say, each juror, I'm going to ask you whether or not this represents your verdict. It's something the defense can ask for as a right, and the court can do so as an option. And defenses usually ask for it, because why not? And here it's a unique circumstance I've never actually seen before, where due to a response from a juror during the polling, that is, after the verdict had already come back, during a response of, is this your actual verdict or not? Due to that, the court wants to now substitute a juror and now have deliberations over again. So a jury has already reached a verdict and we want to substitute a juror. So that's a unique posture here. Let's read on. In response to Jan's question about can you have 11 jurors, the answer to that question is yes. The 12 juror thing is a bit of a historical anomaly, and the minimum number of jurors you need is not clear. The case law suggests at least 6 for certain misdemeanors. For offenses beyond that, what the number is an open question, but can you have 11 jurors? The rules allow for it, and there's no obvious constitutional violation, so sure, that's an option that you can do. Rule 23 permits the court, at its discretion, to excuse a juror for good cause and allow a jury of 11 to return a verdict. Rule 23b3 permits a court, at its discretion, to excuse a juror for good cause and allow a jury of 11 to return a verdict. Now let me pull up Rule 23b3 and we can read it together. So to further answer Jan's question about the propriety of 11 jurors, let's actually look at Rule 23 and what it says. And so we're interested in Rule 23b, jury size. It says, in general, a jury consists of 12 persons unless it provides otherwise. Stipulations for a smaller jury: at any time before verdict, the parties may stipulate in writing the jury may consist of fewer than 12 persons, or that jury of fewer than 12 persons may return a verdict if the court finds it necessary. And then says in B3, after a jury has retired to deliberate, the court may permit a jury of 11 persons to return a verdict, even without stipulations by the parties, if the court finds good excuse to excuse a juror. So there is a rule specifically to deal with this. If there's not an alternate available and you only need to excuse one juror, you can have a jury of 11. So that is what the criminal rules allow for. Finally, under Rule 24, the court may replace a juror with an alternate where juror misconduct or incapacity arises, in which the case the court must instruct the jury to begin anew with the alternate's addition. Here, the court polled the jury, identified good cause to excuse a juror, and excused the juror under Rule 23. The court then replaced the juror with an alternate and gave instructions for the jury to begin deliberations anew, consistent with Rule 24. So here, even though the jury had already come back with a verdict, the court said, wait, this juror is not able to be unbiased, so I'm going to excuse this juror, replace it with a different juror, and I'm going to instruct the jury to begin its deliberations completely anew. So it is a remedy that's available. If at any time the court finds a juror can't be unbiased, like the court has remedies, and this is one of the remedies the court chose. The district court did not abuse its discretion in choosing to seat an alternate and denying James's request for mistrial. Before the court accepted the verdict, it polled the jury and perceived a problem with juror number 8. The parties consented to further questioning of the juror after some debate. As a result of its observations and inquiry, the court had concerns about the juror's candor, memory, and English language proficiency, which reflected that it questioned whether juror 8 understood the verdict as read by the foreperson. Faced with these concerns about the juror, the court acted within its discretion to excuse juror number 8. James consented to the court's decision to excuse juror number 8, but objected to replacing the excused juror with an alternate, presumably because the jury had returned a verdict of not guilty. So they consented to getting rid of that juror, but objected to the replacement because presumably the jury had said not guilty unanimously. And the jury says, wait a second, we're not sure that this is right, and so we're going to excuse the juror. And the defense says, oh, that's fine. Let's just have the not guilty verdict on the record. So that's presumably what happened. I also think it's valuable just to turn to when a verdict is actually final, when it is not final. Because a lot of people might be saying, wait a second, the jury came back with a verdict, isn't it done? Well, there's a footnote here that helps explain this. A verdict is not final until it is accepted by the court. A jury cannot said to have reached a valid verdict until the result is announced in open court and no dissent is registered by any juror. So up until the moment the verdict is actually entered by the court, there is no verdict. So even though the jury had returned a verdict, it doesn't legally exist until it's actually entered by the court. And that's, a clear statement of law. That is not in any dispute anywhere. So that's one of the reasons that lawyers can move for judgment notwithstanding the verdict. A jury can literally return with a verdict of guilty. The defense can literally say judgment notwithstanding the verdict, and the court can say, yep, you're right, not guilty. So there's nothing final until the court enters it. So that is completely a correct statement of law. Perhaps surprising, but it's 100% true. The court replaced the excused juror with an alternate over James's objection. The court told the jury to restart its deliberations, reminded the jury there is no rush to reach a verdict, and the verdict must be considered and deliberate. The court's decision to exclude Juror 8, replace her with an alternate, and give instructions to the newly constituted jury all complied with the rules, and were within the court's broad discretion. Taking the rules together, the district court has discretion to select among the three options under the federal rules of criminal procedure, including seating an alternate and directing the jury to begin deliberations anew when it had good reason to think a juror lacked the capacity to deliberate. Moreover, there's nothing in the record to suggest the decision to seat the alternate prejudiced James in any way. Thus, the district court did not abuse its discretion in replacing Juror 8 with an alternate and instructing the jury to begin again. Yeah, it's the exact opposite of 12 Angry Men, right? It's the exact literal opposite of 12 Angry Men. Because he went from 11 not guilty, 1 guilty, and flipped them all to guilty. So it's the exact opposite of 12 Angry Men. Hey, if 12 Angry Men is valid, the opposite must be valid too, right? And that is the end of the case of United States of America versus Wayne James. In this case, we learned that Mr. James was a member of the Virgin Islands legislature and had appropriated money for official purposes, but he used it for personal purposes. And we learned that during the hearing on the case, the jury came back with a verdict, but the court, upon polling the jury to find out if every juror actually agreed with it, found out that one juror did not appear to understand what they were doing, and using the rules of procedure as allowed, decided to substitute the jury and asked them to begin deliberations again, and then came back with a verdict of guilty. Mr. James, unhappy with this decision, has protested, but it is in accordance with the law. No verdict is final until reached by the jury, and with the substitution of a different juror, the jury apparently was able to come to a unanimous conclusion of guilt, and so that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.